Bismillah, alhamdulillah, wassalatu wassalamu ala rasulillah. Thanks for joining, everyone. It's nice to have you here in our first event as Sakan. This is for our first event, which is like a workshop about the Belgian family law and how it can be important for us as Muslims. Before we go with the lecture and we go with the main topic, I would like first to introduce our organization to you, as almost all of you are new to it, and we try to just get you a touch about it. So Sakan, or home or tranquility in principle, as a definition of the meaning, is our organization, which is a new organization here in Leuven, mainly to serve the Muslim community in Leuven in the social matters. So we try to help our community by supporting the Muslim families in Leuven to provide means of knowledge and consultations about legal, social, and psychological matters. Especially the things that are related to the well-being of the different family members, whether they are the spouses, the children, the parents, the friends. So we try to tackle the social needs of the Muslim society, especially that it's mostly from different backgrounds, from different perspectives. It faces certain challenges that cannot be always addressed by other organizations that work on this social support in general. So it's not to replace the social support organization, but actually to help and complement with these organizations to try to go on together with them, finding the needs of our society and helping them reaching really peace and tranquility in the families. Try to avoid problems among the families, try to solve if any problems happen or something. And actually it starts actually first by just listening to the problem. So that's something that a need that we always see in our fellow families here in Leuven, that at most of the cases, they just need somebody to listen to them, to listen to their problems and try to talk to them. And sometimes they may even sometimes seek advice, whether it's legal advice, and that's why we have our session today, or it's social advice. We just started, so we are trying, inshallah, to recruit more volunteers and more people who can help, more professionals who can help in these legal and social matters. Also to support different kind of families, whether it's single parents or other kind of families and other kinds of people who need support, whether this is a physical support or a psychological support or a social support, or they need somebody to help them with their parenting, they need somebody to help them with their dealing with their friends, they need someone to help them dealing with their parents or with their children or whatever. So that's mainly the scope of our organization, our goals. So it's mainly, we work in 3 different aspects in principle. One of them is sharing knowledge, which is our event today is one of them. Try to build up the knowledge of the community related to things, of these social things like marriage, like parenting, like raising up kids, like how to deal with your friends, how to make good relationship with your neighbors, etc. of things. So what kind of knowledge you need to have a healthy or a good and a peaceful life here, a social life here in Belgium. We will try, inshallah, in the future to provide means of consultation related, as we said, like to social, legal, and psychological matters. And we also try to give some social services like mentoring for people who have difficulties, for example, to socialize in the society, or reconciliation between couples, for example, who have problems reaching like a middle ground or something good between themselves. So that's in principle the scope of the work of the organization. Again, we just started, so we still didn't, of course, not all of these things are active, so that's our first activity here. But we hope that whoever of you is interested to join us, to volunteer with us, or to support us with ideas, or even just to suggest things, or things that he may or she may need now or in the future, and they ask us or give us like indication to things that we can do as well for them, that's always welcome. So you can always contact us if you find our website. You can find a form to volunteer with us, or also you can just send us an email, or through our Facebook page. You can just contact us always, and we will always be happy to contact you. So we come to our session today. So today, again, our first activity, our first workshop about the Belgian family law with Dr. Elise. Thanks for joining us. So I always have this analogy, or it's quite ironic, that before we get a driving license, before we get a driver license, we usually have to study the driving rules. We usually have to know the law, the rules behind it, so that we don't have problems, we don't make offenses, we don't go in trouble. But to the best of my knowledge, very, very little amount of us, or like rarely that someone checks the family law before he makes or she makes a family. And unfortunately, that sometimes leads to a lot of trouble. That leads to a lot of problems. And that's why we thought at Sakan that one way to help our society get over or avoid such problems or troubles is to navigate through the Belgian family law, especially that a lot of us came or come from different backgrounds, different systems of legal systems in principle. So we may have some expectations that they are not here, or also we may have some fears that are not there. So we may have different concepts about the law which are not true, because we expect something different because we come from a different background. So that's why we are happy, we are honored to have Dr. Elise here today. Dr. Elise is assistant professor at VUB in the Department of Private and Economic Law. She is also, in the same time, a postdoctoral fellow, FWO Flanders, at the Family Property Law Institute in Leuven, and she is also a visiting lecturer at the University of Antwerp. And actually, more impressive is that she was a former she was an advisor of the Belgian Minister of Justice for the family property law changes. So that's really makes her like the best one to talk about the family law and to tell us really how can we navigate through it. Please join me to thank her. So the mic is yours.
Thank you very much, Ahmed. What a nice introduction. Thank you for that. And I really like your analogy with the driver's license. It's the first time I hear that, and I think I'm going to steal that from you. So let me see if I can share my screen. Hopefully you can all see it. Is that okay?
Yes, but if I can just, sorry, forgot something to say.
No problem. Go ahead.
The session will be as following. So Dr. Isa will give 30 minutes presentation, mainly to just navigate through the family law, and then we will open a Q&A session. So some of you already submitted their questions through the registration form. You can also always write your questions in the chat. And also, if you would like to have like anonymous questions, so we have, I hope you can see the link in the chat with the Google form where you can submit an anonymous question. So please feel free always to add your questions either in the chat or in this anonymous form.
Okay.
Sorry, go on.
Thank you for that. Let me see. So here is, let me open the chat as well. Someone says, no, we can't see a link in the chat, FYI. And you're muted. Okay, let me see if I can put this on full screen. Can you see the screen like that? Does it work? Just shout if that is not the case. Okay, so
yes,
perfect. So who am I, very briefly, because Ahmed already did it. Indeed, my background is in family and succession law. I was an advisor to the Belgian Minister of Justice for the reform of succession law, and I'm currently affiliated to 3 universities. So my expertise is in the law of persons, family and succession law. I like to point it out from the beginning because I am not an expert whatsoever in Islamic law or Sharia. And that is why it's also interesting for me to see which questions pop up with you guys, because this is not, I mean, this is where we will meet, right? The questions you have from your background and then the expertise that I offer. So I'm looking forward to our exchanges. And what can you expect from the session today? Basically, it will be an introduction to Belgian family and succession law. And there's 3 topics that I will tackle. The first is organizing your family life. You get together, you want to organize your family life. Which possibilities, option does Belgian law give you? So we'll talk about marriage, we'll talk about cohabitation and so forth. And then the second theme that I will tackle is what happens when, unfortunately, things don't work out, the end of a relationship. What are the grounds for divorce, for ending your relationship, etc. And then the third theme, and we'll touch upon that very briefly because it's quite technical, is succession law. What happens if one of the partners dies? But let's start with the good story, the nice story, the plan A, where everything works out, organizing your family life. And so the hypothesis here is 2 people meet, they fall in love, and they plan to organize their lives together. They plan to have a family together. Okay. If that is the case, Belgian law gives you 3 different possibilities. The main possibility, the main option is marriage, a term that all of you will no doubt already be familiar with. And that is also something which exists all around the world, marriage in different forms, but everywhere it's somewhere also somehow comparable because it's a very strong institution in terms of family life. And then we have the second option, and that is a bit more particular because it doesn't exist everywhere. It's something which is quite proper to a lot of Western jurisdictions, and we also have it in Belgium. It's called legal cohabitation in a literal translation, or you might already have heard about registered partnership, which refers to the same concept but with a different term. So we have marriage where you actually make a vow to each other. Legal cohabitation, where you have to register your relationship formally. You go to City Hall and you register your relationship. And then there is a third possibility, informal cohabitation. And that is the option that you have if you don't do anything, basically. You just start living together, but there's no official kind of registration. So marriage is very official. Legal cohabitation is also official, requires a registration. And informal cohabitation, you don't do anything. Okay. It's very important to keep these 3 different options in mind from the beginning of the presentation, because they will come back in every step. And what I would like to point out from the beginning is the difference between those 3 in terms of legal effects. And so I also developed a little analogy of my own, analogy with the wedding cake. So if you get married, that means that you get the whole shebang, the whole package, the entire wedding cake. I mean, you get everything. You get complete. You can eat all you want because the law gives you all kinds of legal effects which are attached to marriage. And then you have a legal cohabitation. That is not the entire wedding cake. It's just a very, very little slice. You get some kinds of legal effects, but that's it. It's only a very limited amount of what marriage has to offer you. And then there's the third type, informal cohabitation. And you see there an empty plate. Basically, it means there is nothing. The law doesn't recognize this at all. It's something that people think perhaps that some legal effects resort from, but that's not the case at all. So that is the 3 themes we'll work with: marriage, the whole cake; legal cohabitation, just a little slice; and informal cohabitation, an empty plate. All right. So let's start with our first option, marriage. And what is very important, I think, in this context is that if I talk about marriage and if Belgian law talks about marriage, then we only refer to the so-called legal or civil marriage. Civil marriage, something that you have to differentiate from religious marriage, and that is very important. This doesn't mean that you cannot get married according to your religion. Of course you can, and Belgian law absolutely allows you to enter into a religious marriage. But that means that the religious marriage as such will have no legal effects in Belgian law. If you want the legal effects that are attached to marriage, you should enter into a civil marriage. A civil marriage, a marriage which is arranged according to Belgian laws. And that is very important because Belgium requires you, if you want to enter into a religious marriage, first you have to enter into a civil marriage. So if you put it in a different way, you cannot enter into a religious marriage without being married first in a civil marriage. And so if I talk about marriage, civil marriage, what you don't have to think about is my picture on the left, because this is the traditional kind of marriage that we see in American movies, which is often associated with Western culture. It's the marriage in a church. But that has nothing to do with the kind of marriage I'm talking about. I'm talking about civil marriage, and it more resembles the picture on the right. You see 2 people sitting at a table and just signing a document. That is what civil marriage is like. So I think it's very important to keep that in mind from the beginning, that it has nothing to do with religion if I'm talking about marriage in this context. What are the conditions to enter into a marriage according to Belgian law? Marriage is reserved to 2 people only, and 2 people who cannot be previously married. Of course, it is possible that you were married in the past, but you then must get a divorce first. So you have to be unmarried, and the marriage is restricted to 2 people. So polygamous marriages are not possible in Belgium. You can enter into a marriage if you're a couple man-woman, but also man-man or woman-woman, because homosexual marriage, gay marriage, has been legal in Belgium for, I would say, since 2003, so already a very long time. To enter into a marriage in Belgium, you must at least be 18 years old, but the judge can allow for an exception. So if you would want to get married with someone who is, let's say, 17 years old, there is a way to do it, but it's not automatically. You should ask for permission to the judge. And then there is an important condition. Both partners have to consent in the marriage. So basically that means that both partners really want to get married, and they want to get married for the right reasons. How should you interpret this? This does not mean that arranged marriages, for example, are not allowed. They are allowed. So it's perfectly possible, according to Belgian law, to enter into a marriage that has been arranged by your family, for example. But you have to pay attention to the fact that the so-called marriages of convenience, also known as so-called sham marriages, those are not allowed. And which kind of marriages are those? Sham marriages are marriages that people conclude solely for immigration purposes, because you might know that if you marry to someone who has Belgian nationality, then you're also entitled to have the Belgian nationality and you can move to Belgium and live here. So that is a very important distinction to make. Arranged marriages, no problem whatsoever. It is possible to have a partner who lives abroad and get him or her to Belgium and get married. But sham marriages, solely for immigration purposes, those are illegal. And that's a very difficult distinction sometimes, because how will Belgian government decide whether or not you are actually entering into a real marriage? Well, the criterion is, do the partners want to establish a real relationship or not? With an arranged marriage, it is also your intent to really create a family together. It's not because the partner has been picked out by your parents, for example, that it's not the partner that you want to create a life with. If that is the way it is, then there should be no problem. There is only a problem if you only marry someone to get that person in Belgium for immigration purposes, and then you say, okay, I've done my job, end of the marriage, we'll get a divorce. That is what is illegal. Okay, I hope that is clear, this distinction. Last condition to enter into a marriage is that it is not allowed to enter into a marriage with someone with whom you have a close family relationship. So for example, and I think it's quite logical, you cannot marry your father or you cannot marry your brother or your sister. So what is the procedure? We have now covered the conditions of entering into a marriage. Let's say that you found your partner, you want to get married, you checked you're legally allowed to enter into a marriage. What should you do then? Well, Belgian law basically prescribes a 3-step procedure. And so you see the 3 steps listed on my slide. The first step is that you have to declare that you want to get married. So this is a declaration of intent. You and your spouse-to-be go to the registrar and declare that you want to get married. And if I talk about the registrar or the civil registry, this is basically just a service at City Hall. So once again, it's very non-religious. It's just something it's the same service you go to if you want to get your driver's license, for example. So you go there and you declare that you want to get married, and they will say, congratulations, very happy for you. Could you please provide us with a couple of documents? So which documents should you provide them with if you want to get married? There are 2 documents that everyone should provide the civil services with, and then there are some extra documents that you should bring with you if you're not registered in Belgium. Okay, so everyone should bring a birth certificate. I have to nuance that. Everyone has to bring a birth certificate, but if you are born in Belgium, the registrar will look it up for you. So then it's not necessary that you take it with you yourself. But if you are not born in Belgium, you have to bring the birth certificate yourself. And I know that for some people that might be a problem because you might have been born in a country where things weren't that really regulated, or you just don't have a copy of your birth certificate with you when you move. So what should you do if you want to get married, but you don't have access to your birth certificate? Well, Belgian law provides for a procedure where you can go to a judge and he or she will certify a document which will then take the place of the birth certificate. So it's perfectly possible if you have no birth certificate to still enter into a marriage, but you have to take a little detour via the judge, declare who you are, what your situation is, and the judge will give you a document that will then take the place of the birth certificate. Okay. Next to your birth certificate, you should also bring your ID. It doesn't have to be a Belgian ID. In principle, it's best if it's a Belgian ID, but if you don't have any, that's really no problem. It's just a document that can certify who you are. And then, as I mentioned, there are some other documents that you should bring if you are not registered in Belgium. Proof of your nationality, proof that you are unmarried, and then proof that you live in Belgium. If you have all these documents and you present them to the register, then the register will give you a proof that he or she has received the documents. And then you have to wait before you can enter into a marriage. You have to wait, and you see on the slides, you have to wait between 2 weeks and 6 months. What does this mean? It doesn't mean that the register will say to you, okay, I want you to wait for 5 months, take your time, I need time to make everything up. That's not how it works. You as a couple, you can choose when you want to get married, but there has to be at least 2 weeks between the declaration of marriage and the actual celebration of the marriage, okay? So keep that in mind if you want to get married, that you go to City Hall in advance, that you plan it so that there's plenty of time for you to get all the documents that you need. And in that waiting period, that is the time when the registrar will also have a look at all the documents and investigate whether or not there will be a sham marriage in certain situations. So that's the waiting period. And then the third phase is very easy. Everything is taken into place, everything is in order, and marriage is celebrated at City Hall. And it's a nice official moment where you sign a document, as I mentioned, and where someone then claps for you and says congratulations. And those are the 3 different phases of entering into a marriage according to Belgian law. And then we come to our wedding cake, the legal effects. So what are the legal effects of marriage according to Belgian law? Well, as I mentioned in the beginning, marriage is really the whole package for Belgian law. This is really the main option if you want to organize your life together. And that also means that it has the most extensive legal effects. So the general idea between marriage is that it creates a shared life between two equal partners. That is what Belgian law puts forward. And so that means that Belgian law expects you to live together, to contribute to the household expenses, and also to take care of each other financially if necessary. And as I mentioned, between two equal partners. So that means that the law also says that both spouses each have the right to work. That's the general idea. You live together and there's also some autonomy to organize your life together. What is also very important is that in principle, if you get married, that also implies that you will build property together. Let's say that each of the spouses work and each of the spouses generate income. That means that as a general rule, your income during the marriage will become shared property. And that is important because it also this claim is also valid if only one of the spouses will work. Let's say that, for example, only the man works and the woman stays at home with the children. Also in that case, all the income that the man has becomes shared property. So the wife will also own this property, co-own the property together with the man. So that's the general idea. All the property, all the income you generate during the marriage will become shared property. But everything that you had before the marriage and also everything that you will inherit during the marriage, that still remains separate property. So as a rule, there will be both shared property, the majority of your property, because you will spend your life together and build it together. But each of the spouses will have some separate property from before the marriage and from everything he or she inherits during the marriage. That is the general rule. But if you want to, you can tailor this rule according to your needs. So you can say that this is a rule that doesn't really feel tailored to your specific needs. In that case, you can conclude a marital agreement. And that is something you will have to do with a notary. And for example, you can go to the notary and ask the notary to draft a marital agreement where you say, I don't want to have any property shared. It's perfectly possible that you only have separation of property, that each of the spouses remains the sole owner of everything that he and she generate during the marriage. Or you can also choose that all the property you already had before the marriage, that also becomes shared property. But that is really something that the notary will discuss with you then, and that you will only be able to do in a marital agreement. The general rule is that everything you generate during the marriage becomes shared. What is then the legal effect of marriage in terms of the children? Well, all children that are born within the marriage automatically have the husband as their father. So the woman will be the mother because she gives birth to the children. And then according to Belgian law, the father of the child is the man who is married to the mother. Okay, so this also means that, of course, you get children automatically. You don't have to do anything. You will become the legal father of the children. And then there's a last point I'd like to point out, but I'm not going to discuss that further because it would lead us too far. But you should also bear in mind that marriage is really the key to all different kind of legal effects in terms of social security law and tax law. For example, if one of the partners dies, we'll discuss that later, but there is also a possibility for the surviving partner to get pension, but only if he or she was married to that partner. Okay, so marriage is really the key to all different kinds of social security benefits. And that is also something which is strictly reserved to marriage, not to legal cohabitation. So keep that in mind. We'll not go into discuss that further, but it's important that you should know that. Okay, so we're still discussing our nice little fairy tale, man and woman get together, want to create, organize a family life together. And I told you in the beginning, there's 3 different possibilities. There's marriage, which we now already covered. And then there's this second possibility in Belgian law, legal cohabitation. And as I told you, legal cohabitation still requires you to make some kind of formal declaration. And there are some legal effects which are attached to it, but it's only a slice of the wedding cake. It's not the entire cake. So what are the conditions then to enter into a legal cohabitation? Mostly those are comparable to the conditions for marriage. As you see it on the slide, I'm not going to repeat everything, but I will tell you something about the last two conditions. You see on my slide mentioned consent. As was the case with marriages, there is also a rule that some so-called sham legal cohabitations are not allowed, because also legal cohabitation can give you some immigration benefits. If you enter into a legal cohabitation with someone, that person will also have the right to move to Belgium and then to be with you, to live together with you, because you are in this legal cohabitation. And once again, there is a rule that you should really want to create a shared life together. If that is not the case, that will be qualified as a sham legal cohabitation and then nullified. And then the last point on my slide is a very important distinction between marriage and legal cohabitation. Because you might remember that I told you that marriage was not open to close family members. You cannot marry your brother, for example, or your father. But in legal cohabitation, that is absolutely possible. You can enter into a legal cohabitation with your father or with your brother. It's really no problem. And that already points out how different this idea of legal cohabitation is from marriage. Marriage, as I said, is the whole shebang, is the whole package. Legal cohabitation is just a way that the law gives you to organize your family life, but it's way more neutral. It's not that much based on love. It's more a sort of practical arrangement. Practical arrangement for people who want to, either have a relationship but don't want to get married, or want to find a way to live together in a more official way with their close relatives. So that is the big difference between marriage and between legal cohabitation. The procedure then, as I mentioned, you also need to make a declaration to enter into a legal cohabitation with a register. So it's the same service that you need to go to enter into a marriage. But the procedure is much more simplified. As opposed to marriage, there is only one phase here. So there's no waiting period. You just go to City Hall and you say, I want to enter into a legal cohabitation. You both sign a contract and it's done. That's basically it. And you also need fewer documents than is the case with marriage. What are then the legal effects of legal cohabitation? As I mentioned, those are far more limited than those which are attached to marriage. You see here on my slides that the Belgian legislator sort of has as a general idea that there is a limited notion of shared life, which means that you have to contribute to the household expenses because that's the essentials. You live together, you have to contribute to the household. But for example, you are not obliged to take care of each other, as you are with marriage, of course, because as I mentioned, with marriage, you have to take care of each other, also financially. That's not the case with legal cohabitation. It's much more free. There's also no shared property. So everything I told you a couple of minutes ago about marriage and about generating property together, which is then shared, doesn't apply to legal cohabitation whatsoever. So everything that you own and everything that you make during the legal cohabitation will remain separate property. Okay, you can choose to conclude an agreement and to make another arrangement. So you can go to the notary and say, I want to have some kind of shared property, but it's organized completely different for legal cohabitation than it is for marriage. And then a last difference with marriage, I would say, is the legal effects which are related to children. So as I mentioned, for children who get married, children who are born rather in a marriage, the husband is automatically the father. That is not the case with legal cohabitation. If your parents are in a legal cohabitation and you are born as a child in that relationship, your father has to go to City Hall to formally recognize you, to formally state, I am the father of this child. And only then the father, the actual father, will also be the legal father. So I think that's also an important distinction with marriage. And then we have our third different option or third kind of way to organize your family life. And as I mentioned in the beginning, I use the image of an empty plate here, because a lot of people think that so-called informal cohabitation also has some kinds of legal effects, but that is not the case. It's just if you just start living together with someone and you don't do anything, for the law, your relationship does not exist. So there are no specific legal effects which are attached to informal cohabitation. There are some exceptions to this in social security and in tax law. I won't get into that, but as a general rule, the law doesn't recognize your relationship whatsoever. And then in terms of the children, it's the same as is the case with legal cohabitation. The man is not automatically the father. You should formally recognize your child with the registrar in order to be the legal father. I see that there is something in the chat. Let me see whether... So Mohammed has an interesting question. He says, can someone be legally married to one person and legally cohabit with someone else at the same time? Thank you for that question. No, you cannot. One of the conditions to enter into a legal cohabitation, let me go back on the slides for just a second, is that you should be unmarried. So you see here 2 unmarried people. You can only enter into a legal cohabitation if you're not married with someone else. So it's a bit of a weird mixed form, because you can live in a legal cohabitation with your father, but at the same time, you cannot be married to someone else. So it's a bit weird, but that's the way it is. Okay. So we have now covered our fairy tale situation, the situation where everything goes well. We have covered how you can enter into a marriage. We have covered how you can enter into a legal cohabitation. But what happens if things don't go well? What happens if your relationship takes an end? As you see here on my slide, what happens if the couple breaks up? What are the legal consequences in that case? And so once again, I'm going to use my same legal options. We're first going to discuss marriage, and then we're going to discuss legal cohabitation. Informal cohabitation, I will leave it out for now, because you already know that there is no specific legal effects which are attached to that. So the end of a relationship, when I'm talking about the end of marriage, I am talking about divorce. So when does Belgian law allow you to file for divorce? What are the grounds for divorce in Belgian law? The general idea is that for the last 15 years or so, I would say, there is no such thing as a fault divorce. That means that for Belgian law, it is not necessary that one of the spouses has done something wrong. You can also file for divorce if things just don't work out. And I think that is very important to keep in mind, because you don't have to prove that the other partner has made a mistake, for example. You can also just say, I'm really sorry, I don't love you anymore, things haven't worked out, I'm gonna file for divorce, and that also works, okay? So that is a general idea, no fault divorce. How is that idea then concretely implemented in Belgian law? Well, there are 2 types of divorce in Belgian law. There is the divorce by mutual consent, and then there is a divorce because of irreparable disruption of the marriage. And let me run through those 2 types of divorce with you. First type of divorce, as I mentioned, divorce by mutual consent. The general idea here is that the spouses agree that it doesn't work out. Spouses agree that the marriage has failed, and they agree that they want to get a divorce. And what's more, they also agree on every aspect of the divorce. They agree on what they will do with the children. They agree on how they will divide the property. So you can only get this kind of divorce, this divorce by mutual consent, if you can agree on everything. And that is, of course, the model that the Belgian legislator really strongly supports, because it's also easier for them. Because as you see at the bottom of my slide, in terms of divorce proceedings, if you get a divorce based on mutual consent, that means that the spouses agree on everything and that the judge just validates what you agreed on. So the judge basically just put a stamp on your agreement. Okay. But then there is a second type of divorce, and that is divorce based on irreparable disruption of the marriage. What does that mean? Basically, it means that things don't work out and that you want to get a divorce, but that you cannot agree on every little aspect with your partner. And in that case, the judge takes a much more central role, because the judge then doesn't only have to validate all your agreements, he or she also has to decide upon the division of property, upon what happens to the children and so forth. And so the judge really decides in that case, but you can still agree on certain aspects with your partner. So how do you then prove that there has been this irreparable disruption of the marriage? Basically, the law says that you can prove this by all means. And as I mentioned in the beginning, there is no such thing as a fault divorce anymore, but you can claim that your partner has made a mistake, has made a fault, to prove that there has been irreparable disruption of the marriage. So it is not necessary, for example, that there has been adultery, but if one of the partners has committed adultery, if one of the spouses has cheated on you, you can claim that this has caused irreparable disruption of the marriage. I hope you see what I mean. So it's not necessary, but you can use it as a way to prove that there has been a disruption of the marriage. Okay, so you can prove it by all means. But even if you cannot prove that there has been an irreparable disruption of the marriage, you can still file for divorce in case of an actual separation. Let's, for example, say that you and your spouse have been living separately for between 6 months and a year. I'm going to put it that way because the procedure is a bit different, but let's say between 6 months and a year, you've been living together for formally apart. You then go to the judge and you say, look, things aren't working out. We've been living apart for the last year. And the judge says, okay, fair enough. That is really sufficient for divorce. You can get divorce based on irreparable disruption of the marriage. That's the second way. You don't have to prove anything. You just state you have to. The only thing you have to prove is that you have been living separately for the last 6 months to a year. And then there's a third possibility. In case of a repeated request, you go to the judge twice. You say there has been an irreparable disruption of the marriage. The judge says, "Are you sure? Do you think about it?" And you come back and you say, "I have thought about it, and I still believe that our marriage is over." Well, in that case, it will also be possible to get a divorce. I see that there are some questions in the chat. Let me check. So Muzam says, what about living with your partner, wife, and legally cohabiting with your or her parents? Yeah, that's what I mentioned earlier. That's not possible. And that is why it's a bit of a weird thing, this legal cohabitation, because it's, on the one hand, it's more or less a marriage light. On the other hand, you can also do it with your parents, but that's the way it is. It's a very weird hybrid form, but you can only enter into it if you're not married to someone else, period. And then Nawar asks, so for instance, you can't marry and live with your parents as cohabitation relation. Okay, I have already mentioned that. Salma says how much time it takes for the second case. I'm not sure what that relates to. For the second case, your legal address should be different for that period of time, or how to prove it, says Mohammed. So I think Salma also mentioned, also is referring to the actual separation, right? So as I mentioned, it should be at least 6 months. But the procedure is a bit different if you have been living together for 6 months, or if you have, so we're talking about the actual separation. So the spouses are not living together anymore, right? So in that case, you're still married according to the law. The only thing that Belgian law says is that if you have been living apart from each other for 6 months to a year, that is a shortcut to divorce, okay? So you can go to the judge and say, things aren't working out, you see, because we have been living separately for 6 months over a year. So things aren't working out for me. And the judge then verifies whether you've actually been living apart and says, I agree. And then you can file for divorce. And so Adam's question, can you get married again after the separation period for 6 months? You are still married. It's not because you are living separately for 6 months that you're not married anymore. It just means that you have a shortcut to file for divorce. I hope that is clear. And even let's say that you have filed for divorce and you are divorced, even after that time, you can remarry. There's really no problem. I mean, if you are divorced and a couple of years later, you both realize that you made a mistake and you want to get into a marriage again, that is really no problem. You can get married again. And then it's a beautiful love story once again, and we go to my first chapter. But in this hypothesis, in this situation I'm talking about, the actual separation is, as I just mentioned, just a shortcut to divorce, right? It doesn't mean that you are automatically divorced. You always have to go to the judge in order to get a divorce. It's never automatically. I hope that is clear to all of you. And then Muhammad says, for the second case, your legal address should be different for that period of time, or how should you prove it? Let me get back to that because I have to verify that. Eva said, well, what about being, okay, let me, because there are a lot of questions popping up. I think they are also relating to other questions already. So let me go to my presentation first and then come back to these.
I would suggest that you finish all the slides and maybe we have more time for the question, because also I think to avoid repetition, etc. Okay.
Yeah, all right. So let me see where I am. Marriage, yeah. So we're talking about the end of the relationship. I just discussed divorce. So I told you there's 2 types of divorce. What are then the legal effects of divorce? What is the consequence of you getting a divorce? Once again, you should keep in mind my image of this wedding cake, the wedding being the whole shebang, which means that the legal effects of divorce are also quite far-reaching. But the first thing you have to know there is that you can arrange basically anything in an agreement. So if you file for divorce and you and your partner agree, you and your spouse agree, both of you say, I'm very sorry, but it didn't work out. You can basically almost agree on everything. You can arrange it in an agreement. You can say this partner gets that, this partner gets that, this partner gets custody, the other one doesn't. You can arrange everything yourself as long as you agree. If you don't agree, if there is no agreement, then the law has this default rule that will apply to you unless there are certain specific situations or specific conditions which are fulfilled. So as a general idea, if there is no agreement on what happens with property and children after divorce, this is what the law prescribes. The law says that once you get a divorce, all your shared property will be divided 50-50. So you remember what I told you a couple of minutes ago, that basically all the income that you generate during your marriage will be shared property. That also means that if you get a divorce, it's split evenly, 50-50, half to the man, half to the woman. After divorce, you're also entitled to alimony. Alimony, which means that if you are in need, if you have financial needs because of the divorce, you will be able to get maintenance or alimony from your ex-spouse for a limited amount of time. And Belgian law, as a general rule, also puts forward that you have joint custody over the children. So both the father and the mother will make the decisions about the children. And additionally, if one of the partners asks so, the judge will first examine the possibility of co-parenting. So you should distinguish those two, because joint custody basically means that both of the parents make all the decisions about the children. Co-parenting means that the children live with both of the parents. For example, 1 week with the father, 1 week with the mother. And this is the general basic idea that Belgian law puts forward. If you have a divorce, the judge will first examine whether it is possible to have an arrangement where the children spend 50% of the time with the father, 50% of the time with the mother. But as I said, this is all up for discussion. You can make an agreement yourself and decide something completely different. Okay, we now discussed the end of a marriage. We discussed divorce. Let me then quickly say something about the end of legal cohabitation. Legal cohabitation, a big difference here with marriage is that there are no specific grounds for ending a legal cohabitation. You don't have these two types of divorce. No, with legal cohabitation, you just go to the register and you say, I want to end my legal cohabitation, and the register says, okay, and that's the end. It's done. So you can end the legal cohabitation without your other partner knowing it, because you just go to City Hall, you say, I want to end it, and you sign it, and it's over. Okay, so there is no intervention of the judge. It's basically done if you go to City Hall. And that also reflects on the legal effects. Once again, the partners can arrange almost everything in an agreement. But if there is no agreement, the basic rule is completely different from what it applies during marriage. There is no division of property because, as I said in the beginning, there is no shared property. Everything is separate, so no division of property. There is no alimony. You cannot get any maintenance in case you are in need. But the rule over the children is the same, because that is really not dependent on whether you are married or not. So also in case of the end of a legal cohabitation, both partners will get joint custody over the children, and upon request, the judge will first examine the possibility of co-parenting, 50-50 living arrangement with each parent. And that is actually the same for informal cohabitation. No specific financial consequences, but for the children, it doesn't make any difference. Okay. And then I come to the last part of my presentation. We discussed organizing your family life. We discussed what happens if your family breaks apart, if the relationship ends, if you get a divorce, or if you end your legal cohabitation. What now happens in case one of the partners dies? What are the general rules that Belgian law has stipulated in terms of succession? And here you see a little example that I also always use with my students. So it's a very basic example of very basic case of Belgian succession law. We have a man and a woman who are in a relationship, and they have 2 children, and the man dies. The first question is, who inherits what? You have the man, his succession, his estate. Who will get which share rather of the succession? Second question is then, who takes care of the children? First question, who inherits what? And this is where it becomes a bit technical. So Belgian law allows you to make a will. Perhaps that is a term you are familiar with because it is something that exists in many more jurisdictions around the world. So there is a possibility while you are still alive to make a will and to stipulate in that will how you want to distribute your own estate. So if we go to my example, our deceased man has had the possibility during his life to make a will and to state in that will who gets what in case he dies. But, and that is a very important but, there is a limit. Because according to Belgian law, the surviving spouse and the children have a so-called reserved share. What does that mean? That means that the man cannot disinherit his wife and his children completely. Okay, so you can distribute a certain part of your estate, but not everything, because there is a reserved share that will go to your wife and to your children no matter what. And what is that reserved share? Children have 1/2 of the estate as their reserved share. So whatever happens, the man cannot give more than 1/2 of his estate to someone else. The children will always get 1/2. In my example, they will each get 1/4 of the estate. Okay, so 1/2 of the estate is reserved for the children in general, 1/4 for each of them in my example. And then our surviving spouse has the right to use the family home and 1/2 of the estate. And this is a very technical term because it's basically what it is usufruct. Usufruct is a very legal technical way of saying that the spouse can stay in the family home and that she also has certain rights related to the rest of the estate. So that is the basic distinction that you have to keep in mind. You can make a will, but you cannot disinherit your children or your wife. There is always a reserved share that you have. With the children, it's half of the estate. With the wife, it's the right to use the family home and to use the half of the estate. So the practical implication of that is, in case my man here dies, that the wife can continue to live in the family home as long as she lives, and that the children need her permission to sell assets because she has the right to use it, okay? So this is very technical, but that is the way it is. One additional thing that I would like to point out, and now we're going back to our legal cohabitation, there is no reserved share for the partner in case of a legal cohabitation. So if you die, you can disinherit your partner in a legal cohabitation completely in your will. It doesn't matter, okay? So this is the hypothesis that the man has made a will. What happens now if there is no will? What happens if the man dies and he didn't left any will? He didn't leave any will, he didn't make any stipulations in terms of what he wants to do with his estate after he dies. In that case, Belgian law says that the surviving spouse has the right to use the entire estate. So you remember the reserved share is half of the estate, now it's the entire estate. And the children will be the actual owners of the estate. So everything will go to the children, but the spouse will have the right to use everything. In case of a legal cohabitation, the partner can only use the family home. And then the last slide, and then we go over to the questions. Who takes care of the children? What happens if the man dies and he has minor children? Who takes care of the minor children in case one parent dies? Well, the basic rule, of course, is if there is still one remaining parent, it's the other parent that will take care of the children. And that is the same if you are in a marriage, a legal cohabitation, or an informal cohabitation. It doesn't matter. It's the other partner, it's the other parent that will take care of the children. But what happens if both parents die? In that case, a legal guardian will be appointed. And then the question is, will you as a parent have the possibility to appoint that legal guardian yourself for the hypothesis that you will die? And the answer to that question is yes. There is a possibility that you as a parent say in your will or in a declaration that you make before the judge or a notary, you can appoint someone to be the legal guardian over your minor children in case you will die. If you haven't made any such declaration, if you have not made any specifications in your will either, in that case, the judge will appoint the guardian over your children, and it will preferably be a close family member. Okay, so this was my bird's eye overview of Belgian family and succession law. I have to say, if I teach this to students, it takes us about, I would say, 60 hours. So this is all I can do in half an hour, but I'm very happy to answer all your questions. And I hope it was somehow clear to you. Thanks.
It was already great. Thank you so much. It was very clear, and actually it's added a lot to me, and I'm sure that it added a lot to all the audience. I think it's many things it's first time for us to hear about, and I have to praise that the language was very easy. I expected to suffer much more, but actually I really like I was enjoying personally.
Thank you. I'm happy to hear that. Do you first want me to tackle the questions in the chat?
Let me. I think that there are. We have like a quite longer list from the form, and I think most of the questions are kind of relevant. So let me try to link them together. So I think a lot of questions come from the idea that is legal cohabitation equal to domiciliation? So just by having domiciliation somewhere, so by registering my address with my parents, does it mean that I legally cohabitated with them or not?
No, and it's an excellent question. So I can imagine that is confusing. No, that is not the case. So if you live together with someone and you're registered in the same address, that doesn't have any consequences. So for example, I mean, if you live together with your parents and then with a partner, if you all live under the same roof, it's no problem whatsoever. A legal cohabitation only exists if you go to City Hall, you and your partner, and you say, we want to enter into a legal cohabitation. So it really requires a declaration. You cannot accidentally be in a legal cohabitation. That won't happen. You can only be in a legal cohabitation if you really go to City Hall and you say, I want to have that, both of us, and you sign the document.
Okay, thank you. Then another, I think a relevant question, can two persons be married while they are a domiciliation, they have their domiciliation in two different addresses?
That's a good question, actually. There is a legal obligation to live together in Belgian law when you are married, but I have to say, the interpretation of that legal obligation has somehow evolved. So it is now interpreted as being an intent. You want to live together, but say for professional reasons you cannot. Let's say that one of the partners, one of the spouses works for an international company and has to travel a lot and spends half of the year abroad, for example. You will still be married, okay? So there is an obligation to live together, but it's interpreted very practically. Then in terms of being registered in two different addresses, I would have to check that. But in any case, also, it is impossible to get an automatic divorce. So if you're registered under two different addresses, still if you one of your the other spouse can use that, I think, as a ground for divorce, can go to the judge and say, look at this, we've been registered at two different addresses for 6 months to a year. So there is divorce because of the irreparable disruption of the marriage. So it can be proof for divorce, but you still need to want to get a divorce. You see, it won't happen automatically. The state will not say they're registered on the two different addresses, so the marriage is not valid.
Okay, yeah, got it. Then another question related to cohabitation as well. So someone says, like, if I can get married to someone abroad, so I can, for example, go to Egypt, get married to a woman in Egypt, and bring her here with family reunion. Can I, for example, go and say that I want to legally cohabitate with my mother, who is in Egypt, and bring her to Belgium?
Yeah. That's also a good question, but no, the Belgian legislator cut off that shortcut because, of course, it would be fantastic, right, for immigration purposes. But no, they prevented it. But there is an additional nuance that I have to make here. Everything that I discussed now is being married in Belgium. In your example, someone goes to Egypt and gets married in Egypt. There is an additional difficulty because then you would need to have your Egyptian marriage recognized in Belgium. That is something completely different. What I discussed now is a situation that you get married in Belgium. So your Egyptian partner would first need to come to Belgium and then you get married here. Okay.
And you cannot have a Belgian marriage abroad, even if you are a Belgian person. So you are a Belgian and you want to marry someone who lives in Egypt, for example.
Yeah, you can. It's an interesting question. For sure, already you can have Belgian law that applies to your marriage. That is possible. That's no problem whatsoever.
But you have to have the contract in Egypt first. Or can you have like the just a Belgian contract?
No, you can for example, so the contract, the marital agreement, which I discussed, you can also go to a Belgian notary before you get married and have them make it up and then get married so that the contract is valid immediately. So that is really no problem. So the Belgian law can govern your marriage. That is no problem. The only thing I'm wondering is, can you conclude a Belgian marriage, really the act of concluding if you're abroad? And what I think is then that you would need to go to the Belgian embassy abroad.
Yeah.
But I think in that case, it might be a bit more efficient to have a marriage abroad, according to Egyptian law, for example, in your example, and then have it recognized in Belgium. But it's two different ways of doing it. Yeah.
Okay. Related to that question, also there is another question related to recognizing a marriage contract from abroad. So I am already married in Egypt. I came with my wife to Belgium, and now we bring our marriage contract, the Egyptian marriage contract, to the Belgian city when I register to live here.
Yeah.
And then automatically the Belgian law applies to me, but I made the contract based on the Egyptian law.
Yeah.
So which law is applied, and how can I take
Yeah.
the law, the Egyptian law, to apply it here in Belgium, for example?
Yeah. So everything which has an international component is extra difficult, if I can put it that way, because the first question that you rightly put out, it's not, the first question is which law will apply, right? And then you can look into the content of the law. Then you can see what the law actually stipulates, but first you have to know which law applies. So Belgian law will apply for divorce and so forth if you're in Belgium. But your Egyptian contract, I would have to check what Belgian law says about that. If I'm in general, I would say that if your contract has been valid in Egypt, then it will continue to govern your property relations also in Belgium. But there's one exception to that, and that is a so-called public policy clause. So if there is something in the contract which really goes against Belgian public policy, we call it, like the basic foundations of Belgian, the Belgian state, then it's possible that the judge will not apply that specific part of your contract.
Okay.
So yeah, I know it's very technical now. Yeah, it's super complicated.
But, I think this has a lot of questions, because a lot of the people who attend the lecture now also have this kind of case.
I thought so.
But also, for example, another question pops up, like if a Egyptian couple who are married in Egypt and came here, can they go back to Egypt for divorce and then bring their divorce certificate to Belgium, and then they will be considered divorced now in Belgium, and they don't have to make this division of states and whatever?
I mean, it would also depend on what Egyptian law says, right? Because, I mean, will Egyptian law allow you to get a divorce according to Egyptian law if you don't live in Egypt anymore? That's another question,
yes.
right?
Yeah. That's possible.
Yeah, okay.
I can say.
Okay. In that case, once again, it won't be recognized automatically, but you can indeed bring a certificate and it will be recognized in Belgium. Yes. But there's always, it's always an additional step, right? Because everything which happens abroad will have to be certified in Belgium.
But still the Belgian law will apply in this case.
The Belgian, it's two, now we're getting really technical, but there's two kinds of Belgian laws. The first law is the law which says which law applies, if I can put it that way. So there is Belgian law has as a specific statute which arranges which law applies, and that law will apply in any case. But whether Belgian law will govern your marriage contract, that is a different question, and that is why I didn't touch upon this, because I mean it's impossible to explain this without getting super technical.
Okay. Yeah, but I mean, also there is another question in the chat related to that. I think it's quite important for a lot of people. This, for example, there is a question here in the chat says if a person was married in India and it was already legalized in Belgium through the consulate, in that case, if the person get divorced in his or her home country, will that be valid divorce in Belgium? So can he already get married again, for example, and he does all the things, he is now not married in front of the Belgian law anymore? Or will he has to go to the court to go for divorce here?
Yeah, no, you don't have to go for divorce, but you will need to have your divorce certificate certified in Belgium. So
yes, you made with your marriage certificate.
Exactly. So there's no automatic legal effects, and it can be difficult administratively, because often people will require a translation, especially if it's I mean, if it happened in Egypt or in India and it's languages that Belgian people don't understand, you will need a translation and an official.
But we do the same with the marriage certificate usually. So I think
exactly.
the procedure, yeah. So we do the same. Okay, that's good enough. Thank you. then there is like a question about proving that you are not married if you are not born in, if you are not Belgian in principle. So if you are not, you said that one of the requirements, if you are not Belgian, that you prove that you are not married. And in this case, sometimes, usually you just get it based on like family composition document from your home country, and then you translate it and you legalize it, etc. Of these things. But sometimes it's not that easy. Sometimes it's also expires throughout because it has to be maximum 6 months old and expires. And I personally know few people that really suffered a lot, and some of them even cannot really prove it at all.
Yeah, I understand. And it's the same problem.
So is there is there another way to prove that you are not married abroad?
It's more or less the same discussion we have with birth certificates, right? Because in some examples, it's just impossible to get a birth certificate. I mean, if you're from Afghanistan, for example, I mean, how on earth would you get a proper birth certificate if you're not registered yourself, for example? And so there is a way in Belgian law, which is sort of a shortcut via the judge. That means that you go to the judge, and the judge will, you bring some witnesses, and those witnesses will testify on your behalf that indeed you have been born at that date in that country. And then the judge will take that as a proof and make a certificate of that, and that will then replace what you need to offer. I would have to check whether that possibility is also open for proof of being unmarried. I'm not sure. For birth certificates, I'm positive that it is an option. For being unmarried, I'm not sure. But in general, that is the way. If you really cannot get any documents, you can go via the judge. But just to make something clear, Ahmed, if your certificate expired, that is not a sufficient reason to take the shortcut. So it's only if it's really impossible for you because of the situation in your home country to get this.
But I mean, that's like if you make it every 6 months and then it expires every 6 months, it will stay to infinity. So it's still not possible anymore. There is a question about close relatives. Are cousins considered close relatives?
Yeah, for getting married, you mean?
Yes.
Yeah, that's right. That's an interesting question. So the people I put on the slide are the people that you absolutely cannot get married with. And that is only your father, your mother, your own children, or your brother and sister. All other relatives, people you are closely connected with, are you, let me put it differently, all other relatives, people that you are related to, but not in that close way, you can get married to, but there is a possibility that the judge would need to say it's okay. So it's absolutely impossible. Father, children, and brother, sisters, cousins, it's possible. It's no problem.
Okay.
Yeah.
Okay. Then we have like
so many questions popping up.
Yes, a lot of in the chat and a lot here as well, trying to combine. So, for example, about this shame marriage, having the concept like how to prove or not to prove that it's a shame marriage. So for example, it's by default if a Belgian partner and a non-Belgian or both are non-Belgian. So is it by default considered like, and you have to really prove that it's not the case, or what is the procedure for that, or how to prove?
No, it's the procedure is for getting married is the way that I described it, right? So you go to the civil registry and you declare that you want to get married, and then there is this waiting period. And in this waiting period of two weeks, between 2 weeks and 6 months, I think, the register can look at your application. And then if there are doubts whether or not this is a sham marriage or not, then the register will refuse your marriage. And then you will have to escalate your situation to the judge. But the mere fact that you want to get married with someone who is abroad is no possibility whatsoever. The mere fact, I mean, even an arranged marriage is no problem, right? So the criterion is for marriages is the only reason that you want to get married for immigration purposes. That is the criterion. So the state has to prove that the only reason you want to get married is for immigration. So even if immigration is part of the reason that you want to get married, then it's no problem, as long as you really have the intent to build a life together.
But then it's the state that has to prove that, not me. So it's not the person that has to prove that it's not for that. It's the state that has to prove that it's for that.
The problem is that, I mean, if the register is not convinced of the validity of your marriage, the register will refuse your marriage, and then you get to the judge. And then you get to the judge, and then, of course, the situation, the question of who proves what, of course, you also want to, I mean, make your case strong, right?
Yes.
So,
yes. Okay.
Yeah,
it's would get difficult, of course. Then there is a question about, for example, if you said that you like both partners at the marriage contract can agree on the property sharing in the case of divorce. So, for example, they can agree that we don't want to share, but we, for example, if we have a house, it will be for the wife, or it will be for the husband, or something like that. But can they agree on other terms of divorce, like, for example, the custody? Can they agree on that beforehand, like in the marriage contract?
That's a very good question. So for this, you have to make a distinction between the property and the more personal effects focused on children here. So everything which is property related, you can make an arrangement even before the marriage already. So before the marriage, during the marriage, if there is no talk about divorce whatsoever, you can really put everything you want in a marital agreement, and that's it. But everything which is related to children and also to alimony, you can only make an arrangement in case you are already divorcing.
Okay, so you cannot do that beforehand.
No.
And you cannot apply, for example, the again when it comes to like foreign contracts, like for example the Egyptian contract that you came with, you cannot apply the custody laws of Egypt in this case.
No.
You have to apply you either agree during the divorce, or you apply the Belgian law through the judge if you don't agree.
In any case, for Belgian law, the main aspect here is the best interest of the child. So even in Belgian law, if you made a custody arrangement and the situation changes, you can go to the judge again, and the judge can revisit the custody arrangement. And for sure, that will also be the case if there is a custody arrangement which has been concluded abroad. So, I mean, let's say that you get a divorce abroad and you made an arrangement and it's somehow valid. You come back to Belgium and one of the ex-partners changes his or her mind. You can go to the judge and the judge will revisit it. So children, you can, I mean, it's always the best interest of the child, so you can revisit it all the time. Property is something else. Property, you make an arrangement, then it's done, right?
Yeah. Okay. It's clear. I have a question that I think we discussed before, I remember, but I don't know if you now have an update about since our last discussion, which is about the child allowance. So, for example, those who...
I have not. Yeah, sorry.
Okay, sorry. Okay, so maybe if you ever have it, just send it by email and we can update you.
Yeah, but I mean, so the question, if I'm not mistaken, was do my parents lose a child allowance, right?
So yeah, we said before that now the law said that it's kind of intent to live together. So in principle, yeah, theoretically speaking, you can just get married while he's living with his parents and she is living with her parents. But then the question is, can they still get their child allowance during that time or not? Will the marriage like cancel the child allowance or not? That's really the
question. It's a good question, but I don't know it, because as I mentioned in the beginning, my expertise is family and succession law, and this is really social security law. So it's, I mean, I know for you it might be artificial for you guys to think along these strict fields of law, but for me it's something which is completely unrelated to what I do. Yeah.
Okay. Then there is a question about custody and co-parenting in case of informal cohabitation. So they were, so is it still applies the same rules, or for example, they were not formally cohabitating, or they were not formally married and they had kids and then they separate?
Yeah.
And in this case, there is no actually actions for separation. So what is the procedure, or what happened in this case?
It's a really good question. So if we go back to marriage and to divorce, you remember that there's always a judge who has to intervene, right? So there's always, I mean, you always have to make a custody arrangement or the judge will do it for you. In case of informal cohabitation, there is no judge that will intervene. So you just, I mean, if you live together and then you just stop living together, basically the judge will only come into play if there's a conflict. Because there is no judge if you don't get divorced, if you haven't been married, there is no judge whatsoever who is involved in your situation. So to answer to your question, if you've been in an informal cohabitation and then you just break up and you start living at two different addresses, you can basically arrange the custody the way you want. But if there is a conflict and one of the partners goes to the judge, then the judge will look at this from the same angle that I already discussed, namely, joint custody is the rule, co-parenting is the rule, but it's possible that there is a different kind of arrangement. But those questions will only come up if there is a conflict.
Yeah.
Yeah.
Okay. Yeah, maybe I would like to look at the chat a bit because it's already a lot. Maybe
It's
you can
exploding.
help me if, yeah, you can help me if you'd like. Who pays alimony to whom, for example? That's the last question. So is the husband pay, the divorcee man makes the divorcee woman, or vice versa, or who can say that?
Excellent question. It depends on who is in need. So there is no, as I told you in the beginning, the idea of a marriage is that it's between two equal partners. So man and woman are completely equal. And the result of that is also that it's also absolutely possible that the woman has to pay alimony to the man. In case that, let's look at the example that, for example, the woman has a career and the man stayed at home with the children, and then there is a divorce and the man is in need because he doesn't really have any job at the moment and he needs some kind of alimony to bridge him getting financially independent. Then it's perfectly possible that the wife, the ex-wife, will pay alimony to the husband. But the thing you have to know about alimony is that it's really, it's not a lifelong commitment anymore in Belgium. The idea is that it's bridging, it's helping the other partner to get out of his or her needs and to become financially independent again. And you will only have to pay for that period of time.
Okay. Then there is
the period
another.
Is relative. Yeah, it's relative. And it also depends on how long you've been married, because the longer the marriage was, the longer you will have to pay alimony.
Okay. Then there is a question. What about if the couple have a shared house and one of them wants divorce and the other doesn't want to divorce? How the divorce happens in this case?
Yeah, that's
who gets the house, or who lives there, and who goes out? Or
yeah, that's unfortunate. But as I mentioned, when I was talking about divorce, there is no such thing as fault divorce anymore. So that means that basically, if one of the partners wants to get a divorce and the other one doesn't, I'm really sorry, but there will be a divorce. I mean, it's you cannot be obliged to stay in the same situation. And then you have to think about my two types of divorce. There was divorce by mutual consent. In your case, in this example, that won't be the case. And then there's divorce because of this irreparable disruption of the marriage. In that case, the judge will intervene and the judge will decide who gets the house. And there are specific rules in Belgian law who you should give preference to in case there is this kind of situation. So they will look at who will take care of the children. They will look at whether or not one of the spouses uses the house for his or her job. For example, if one of the spouses is a dentist and the dentist practices in the house, that will also be something which is taken into consideration. And then the third element that the judge will look at is if there has been any violence in the relationship. If there's been any domestic abuse, then the victim of the domestic abuse will almost always get the house.
Mm-hmm. If you get married abroad and your partner comes here through a family reunion visa, do you additionally need to get married after your partner is here, or you are by default considered married?
That is very technical. I mean, because in this situation, in this example, it's not a Belgian marriage, right? So no. Let's say that a couple has been married in Egypt, once again, because we were talking about Egypt. Let's say that a couple got married in Egypt, and then, for example, the woman gets a visa for Belgium. because she will work here. Then, according to family reunification arrangements, it's no problem whatsoever that the husband will join her. So you don't have to get married again. But once again, you will need your marriage to be certified in Belgian law for it to be recognized, and then there will be this immigration consequence.
Okay. Then a question about, like you said, for the divorce to happen, one of the reasons to live separately for 6 months or 1 year, then how to prove that you're living separately? Does it have to be only through domiciliation, or there can be other ways?
Let me check it, because it was a good question a bit earlier, and I have to say that I'm not entirely sure. I can just quickly look it up. I mean, because it depends. I'm not really sure what the law says in this regard. Yeah, I'm sorry. I would need to look it up. It's
okay.
Yeah. I'm not really sure.
Yeah, you can always send it to us, and we can share it with our audience. Then a question. I think there are a lot of questions about succession law. I don't want to make it too much for you. Just please, when you think you are tired or something, just.
I mean, but succession law is where my heart is. So finally, we get into the main stuff.
So you like it? That's why I keep it to the end.
Save the best for last.
Yeah. So there is a question about, for example, how much estate from the estate of the person who passed away goes to taxes. So he said here like half to kids and etc. But
yeah, that's, I mean, once again, so that is tax law. So it's out of my expertise, but it also, I mean, it's not so easy to answer, because, for example, the house, if the house goes to the surviving spouse, you won't have to pay any taxes on the house. For everything else, it depends on how much money and how much assets you will give, because as it is with income taxes, it's progressive. So it depends on the first scale, it's this percentage, on the second scale, it's this percentage. And then we are only talking about, in my example, we were only talking about the situation, wife and then children. It becomes way more complex if there's no children, but for example, there's brothers and sisters or uncles. So I cannot give you a number, because it really depends on the specific situation.
Okay. There is a very nice question. If somebody already filed for, like, asks for divorce, but the divorce didn't happen yet, and then he dies, does the inheritance go to the spouse or not?
It's an excellent question, actually. And so for, you remember that there's two types of divorce. So the divorce by mutual consent. One of the things you would need to stipulate in your arrangement is what happens to your inheritance in case you die before the divorce is finalized. So Belgian law requires you to arrange this yourself.
Okay. But what if it's the other type of divorce?
If it's the other type of divorce, I think it's the, so how much, I mean, you're making it really complicated for yourself, right? I mean, because it's, so the marriage in itself will continue to exist until the divorce is final. But in terms of property, the marriage will stop at the moment that you have filed for divorce. So that is a bit of a problem, because there's, I mean, it's different between the two. And then I'm going to leave that open, because I'm not entirely sure how it's done. Yeah.
Okay, sure. Then there is a question about the will. Does we always have to register the will at a notarius or something, or it can be just a signed, written something?
Yeah, it is even valid if you write it in lipstick on your mirror, and you date it and you sign it. The only thing which is required is that it's signed, it's handwritten, and it's dated.
Okay.
Yeah, but of course it's also a question of proving that it's a, I mean, it's the actual will, right? And that is why a lot of people, if you do it with the notary, then you're sure that, I mean, it will be, people will believe that it's your actual will, and that it will be found again. If it's just some paper in your night drawer, then a jealous child who doesn't get anything, or is only gets a reserved share, can just, I mean, tear it to pieces, and it won't exist. So
okay, yeah. And then there is another question about the guardian. For example, you said that if both parents die, then the children go to a guardian. You said that we can specify the guardian in the will, or otherwise could use a closest relative or something like that. So what if there are two questions here actually. So what if there are no close relatives in Belgium? Do they go to the close relatives in the home country, in Egypt, for example, in this case? And also, can we specify somebody who is not resident in Belgium to be the guardian in the will?
Well, it's quite difficult. I mean, it's so once again, for children, the main aspect will always be the best interest of the child, right? So if children have been living here for all their lives, and for example, the parents die when they're 15, it will not be in their best interest if they get then, if they must move to Egypt to live with the guardian there. So I'm not sure whether it's, I mean, if it's technically really not allowed to do it, but I'm quite sure that it won't happen.
So even if you put it, the judge may not approve it.
I mean, the judge will always still reason in terms of the best interest of the child. Yeah.
Okay. So it has to be always approved or not approved by the judge at the end.
It's, I mean, I think it's a bit too, because we're talking about a super specific situation, right? I mean, it's a legal guardian who is not living in Belgium. I mean, once again, in that,
it's very relevant. Actually, it may be very specific, but it's very relevant for a lot of people who are here. So, for example, that's something I think about myself. What if both me and my wife die, and then who would take our kids if we don't have any relatives, for example, in Belgium?
Yeah, I see what you mean. Do you prefer then that your children would move to Egypt where they don't know anybody or haven't lived?
But they have their grandparents, for example, there. They have their uncles and aunts.
It's interesting. I can look it up. I mean, I can look it up and I'll send you the answer, because for me, it's a super specific situation, but I can see for you guys why it's so relevant, right? Yeah.
Yeah. Getting back to marriage, someone asked if they're somebody married religiously at the mosque, for example, and doesn't get only having either legal cohabitation or informal cohabitation. Is there any consequences for that, positive or negative or anything, or both are completely separate?
Actually, if the marriage in the mosque is concluded in Belgium, they're not allowed to do it if you're not married in a civil marriage first. So, I mean, if that is done, then the mosque will have made a mistake because it's not legal. Yeah.
It's kind of offense in the mosque, actually. That's I heard a lot before. It's kind of offense that the mosque has made a legal offense at this case. That they get people married without having a civil marriage first.
Yeah, and I mean, it's even in the Belgian constitution that if you want to get married religiously, that you first have to have a civil marriage. So it's
and legal cohabitation will not work in this case. So if you have legal cohabitation, you cannot just take a legal cohabitation and go get married in a mosque. You have to be really a marriage.
It has to be a marriage. Yeah.
Okay. I think I'm almost done with the questions. Yeah. I don't know if you can see anything in the chat. There are a lot of things in the chat.
I stopped following some time ago because it just keeps on popping. I mean, I'm happy that there's so much interest in what I've been telling, and I hope it was. I mean, I have the feeling that it caused a lot of, it has raised a lot of more questions, but I also hope that it has answered some questions. So
yeah, I think it was clear. As I told you, it was kind of an important topic. So we hope people enjoyed it. I enjoyed it myself.
Happy to hear that.
And I think it's kind of things that we live in, and again, because we are not familiar with the Belgian legal system, so a lot of concepts can be different to us. And
I understand, yeah.
And that's important actually to know what is going around. So what is really there, and I think it was very useful. So thank you so much.
I'm happy to hear that. Perhaps as a general advice, not a lot of people know that, but the first consultation with a notary is for free, legally speaking. So if you have questions and you're really tangled up in your case, I mean, the notary is legally obliged to to give you an explanation about Belgian law for free. So
okay, that's great. But yeah. It's not to use this first consultation to make a contract.
No, that's not how it works. You would need to pay for that.
That would be, it would have been nice. Okay, thank you so much again. We really appreciate a lot your time and there are a lot of questions. A lot of people ask actually if you can share the presentation.
Yeah, I'll send it to you, and
the slides.
You can share it. It's okay.
Okay, yeah. That's very nice from you. And yeah, we are very happy to have you here. And maybe if in a after some time you also would like to have a continuation for this. Okay. And also we will still have more questions, so they digest what you said today, and in 6 months they bring more real life cases.
I'm fastening my seatbelts already. Thank you for your interest in general, and best of luck with your organization. So
thank you so much.
Okay, bye-bye.
Thank you so much. Have a nice day, evening. Thank you. Bye-bye. Thanks everyone for attending, and we hope to see you a lot in our future events and stuff. Sorry if there were any questions that have been not answered, like missed here or there. We will try to again filter all the questions. If there are other questions that we didn't really see, we will try to send it to Dr. Elisa by email if she would have time. That will be very appreciated. Also, if she can send us an answer, and we try to share it with you, inshallah. Thanks again, Dr. Elisa. Thanks everyone for joining, and see you again. Assalamu alaikum wa rahmatullahi wa barakatuh.